there's an override, but you gotta constantly go over there and, because it keeps trying to shut it back down. I imagine, especially if he left late. Is it time? Is it 5? We got 1 minute, but we will start on time. Rob. Time earlier today.
Never mind.
All right, it's 5. All right. Well, welcome everyone. Let's get started tonight. This is the workshop from the Intermountain Fair Housing Council for some training that's provided by them for us and everyone listening on the internet, or as well as that are present. So, Linda Lopez, welcome, and we'll have you come up to the podium and get started as soon as you're ready. Thank you.
Good evening, Councilman. I just wanted to do a brief introduction. This year is the Community Development Block Grant Program celebrating 50 years. And so to mark this occasion and kick off National Fair Housing Month, which begins in April, we organized a quick training course for fair housing for our city councilors and just for our city in general. We have invited them to provide us with a refresher course on fair housing. Intermountain Fair Housing is a nonprofit organization. They attempt to eradicate discrimination through education on fair housing laws, housing information and referral, housing, counseling, and assistance with mediating and or filing fair housing complaints, among other things. They also provide education and outreach on fair housing laws and practices to housing providers and others. And so, a quick little fun fact, I graduated with Linda from Caldwell High School, class of 2005. And so I am proud to introduce Linda Bozio Lopez.
Hello, everyone. Thank you so much for having me here today. So, like she mentioned, my name is Linda Bozio. I have worked with the Intermountain Fair Housing Council for about 13 years now. And this has been my primary focus as my career. So I hope to bring some great information to you and hopefully provide some additional training, a little more in depth. So I hope that we can become a resource for you. So before we begin, we usually do a little survey as far as your knowledge of the Federal Fair Housing Act. 0 being absolutely nothing, and 5 being you are extremely well versed. So if you want to jot that down on your piece of paper, that'd be appreciated. I will ask at the end if you learned anything. So it's also information for me as well. So I will say I am not an attorney. So if you do need legal counsel, you should contact your attorney. We do provide fair housing training. We provide what we call hot topics, so which are typically service animal information, because that's a big topic among fair housing. And if you need additional information or education, feel free to reach out to us. So Dominic had mentioned we are a nonprofit. We're a statewide, we're a statewide organization. We do receive our primary funding through HUD. We do have some private grants and other grants that we apply for as well. Our main mission is to eradicate discrimination. In the state of Idaho, we have our State Fair Housing Act. It covers 6 protected classes. Our Federal Fair Housing Act covers 7. So that's the law that we typically work with. We have worked with other laws that will help ensure that we are protecting the rights of every individual. So one of the things we like to start off with is a land acknowledgement. Sorry, this little clicker's it's moving quickly. So the land acknowledgement regarding the native lands, and originally these are the native lands, and if I could take 10 seconds so that we can acknowledge the land itself. So the Federal Fair Housing Act originally was passed in 1968. It started off with race, color, religion, and national origin. It later, sex was added, which it does include sexual orientation and gender identity. In 1988, disability and familial status were added. Disability meaning physical and mental disabilities, and familial status meaning the children under the age of 18, but also women that are pregnant. So here's additional resources if you want to learn more about the Fair Housing Act history. You can, I think the PowerPoint will be shared with you all, so you can use the link. We also have on our website the Fair Housing History of Idaho, so you can check that out as well. So as we all know, there is an affordable housing crisis, and each state has is dealing with that. In Idaho, we are among 30th, and in order to have a modest apartment, you should be making about $21.53 an hour. As we know, the rate of housing and our wages are not keeping up. It's something we point out because we do have a large margin of our population that is extremely low income, that are housed burdened, over 50%. So here's a couple of the information based on the Out of Reach report from last year. If you want to take a second to look at that, I'll be right back. So before I move forward, I do want to mention that the Federal Fair Housing Act, there's two mandates. The first one is to eliminate housing discrimination as best we can in rental sales, financing, and real estate transactions. The second is in basically affirmatively furthering for housing, essentially asking its program participants to do anything possible, meaningful action to overcome patterns of discrimination. So that would be in any of your programs and any of your policies, and making sure that you are accessible to folks of all demographics. So who needs to, well, in order to file a fair housing complaint, folks will contact us, and they must be a member of a protected class. So they must be in one of the 7 protected classes. It does need to be a covered housing provider, meaning the housing provider needs to have 4 or more properties or be in the business of housing, so 3 or more rental transactions. The complaint would have to be within a year, and there should be some connection to what the discriminatory act is. So if folks are coming to Intermountain saying, I got denied housing because they said I have too many children, that then connects the discrimination to the protected class. And that is one of the complaints we do get. So under the Federal Fair Housing Act, we have a list. It doesn't include everything, but essentially it'd be multifamily dwellings of 4 or more units, manufactured homes, group homes, private homes. It could be vacation homes. Shelters is one of the big ones that folks typically think, oh, if it's an emergency housing situation, the Federal Fair Housing Act doesn't apply, but the Federal Fair Housing Act does apply as long as the person is under the assumption that they will return night after night to seek shelter at the particular shelter. We also have the Federal Fair Housing Act covers condos, duplexes, and I don't think it's listed. Okay, vacant lands. Typically, there's mobile homes or RVs also, so that's one thing that we do like to mention. Nursing homes and assisted living are big ones that also need to abide by the Federal Fair Housing Act. So like I mentioned, in rental sales and financing, real estate, the Federal Fair Housing Act, these are the types of of the transactions where we see a lot of complaints. And one of the things, a recent case, it is design and construction. The city allowed permits to go through. Unfortunately, after we did our review, the multi-family housing complex is not accessible to people with disabilities. There was lots of issues, and now we're in the process of trying to figure that out and work with the housing provider to get everything, I guess, retrofitted and make the client whole again. So those are the types of transactions where Intermountain Fair Housing Council would work with certain individuals and the developer, the contractors, the property management company to ensure that that does get fixed and remediated. I'll move forward. So these are the common discrimination practices that we see is making housing unavailable, and discriminatory terms and conditions, allowing for there to be rules for one type of demographic but not for another type of demographic. Discriminatory statements, saying, "Oh, that's too many children. I can't rent to you. Oh, your wheelchair is going to damage my floor. I'm not going to rent to you." Steering, basically saying, "I'm not going to let you live on the second floor because you'll make so much noise. I'm going to make sure that you're on the first floor." Even though that could be, some folks say, to keep kids safe, things like that, it should always be the individual's choice to select where they want to live, as long as they're able and capable to apply and qualify. Intimidation and coercion and intimidation. This typically happens after the fact, once an individual has shared that they're involved with fair housing and or are enforcing their federal fair housing rights. We have had some folks decide to retaliate against the particular individual, so then that's another claim that goes on a complaint and is sent to HUD. So this also provides more examples of what making housing unavailable would look like. Imposing different rental charges would be one. Evicting someone could also be seen as one, depending on the situation and the facts. Discriminatory terms and conditions, typically failing to make repairs for a certain population versus another. Harassing individuals, especially if they're seeking services. Discriminatory statements could be pictures, words, anything that, if it's published also, we don't typically see this, but we also have to mention that. Steering, lying about the availability, asking folks to go to a different complex or a different area of the city or the town. And then intimidation and coercion, it's unlawful, and we usually will help folks file with that. So the Federal Fair Housing Act is the law that we work with. So folks that do have a fair housing complaint typically call us, and we'll provide their side of what's happening. Should there be merit to those allegations, then the individual has a year after after that has occurred to file the complaint. That complaint would then go to HUD. If HUD does see that there is a reasonable cause, they would cause the case. If the case does move forward, the individual can choose to go to an administrative law judge or go to the Department of Justice to seek remedies. Excuse me. In our organization, we also, should the case be strong enough, we do file fair housing complaints in federal court, and that statute of limitation is 2 years. We do file at times with HUD, and then if HUD isn't moving forward quickly and or swiftly, we will pull the case and file it in federal court. And we'll move forward. So again, the 7 protected classes are race, color, religion, national origin, discrimination, and familial status. This is particularly talking about folks of a different national origin, so ensuring that programs and or places that have federal funding offer LEP, which is a language access plan, and it's limited English proficiency. So, for instance, an application or rules, if the standard is English, if you have a high population and or if you have folks seeking a different language of documents and or services, we would, the Federal Fair Housing Act and AFFH would require that if you are receiving federal funds that you do have a language access plan and that you do have a system in place to handle those types of phone calls and or inquiries. We do have resources for if you don't have a language access plan. That's typically, we partner with Gary Haynes, and he typically does that. So here's the list of the resources. Obviously, the Department of Justice. Gary Haynes is a partner here in town that, well, in Boise, that would offer some access. We also have a language access guide on our website, and the link is above. So with federally funded entities, there should be a language access plan. There should be procedures on how to handle that type of inquiry. Typically, there's an I Speak card so that individuals can show or point to what language they need. Again, vital documents being translated, and training staff on how to handle those types of walk-ins and or phone calls. I know that we utilize a language access line, and that's typically how we handle most of the phone calls. We also have a partnership with interpreters in town that will help us when we need to meet with folks in person, and engage in affirmative marketing, ensuring that you are getting, that you are sharing resources and or what you're doing with the community in different languages if at all possible, and monitoring and evaluating if those are working. One of the other things that comes up when we deal with national origin is folks dealing with needing to provide alternative rental and credit history. So folks that are new to the country may not have credit history established or may not have rental history established. So offering different ways for folks to provide that, not automatically excluding folks from housing. We want to make sure that we're inclusive to anyone that moves into our state, and ensuring that you also protect your property as well by doing what you need to do to allow that. So there's been folks that have offered, that have provided a cosigner and or allowing agencies to be the cosigner as opposed to individuals. So that's something that I know that has been sort of creative. The other issue that we typically run into is with criminal background. Essentially, bottom line with criminal background, it should be on a case-by-case basis. It shouldn't be an automatic no to anyone that has a criminal history. Obviously, you should review them. I know that there have been some housing providers that will automatically, that will see something and will say no, but that wouldn't be the fair housing way to do things. We are asking folks to do their best to ensure that if they are utilizing a third-party verification system, that there is a way to ask for sorry, the word is escaping me, to offer an appeal process so that that can happen and that can be discussed with the individual that's trying to apply for housing. Let's see here. So best practices, reasonable accommodations for screening policies. Some people would say ignore arrests, but again, that will have to determine on what your criminal criteria looks like as far as what you're going to allow. And we definitely would say stay away from the no automatic conviction. So recommendations. So don't ban folks. Don't ban people based on convictions, other than convictions. Don't ban people based on offenses that are older than 7 years. That's been HUD guidance that has been released. Anything older than 7 years should not be taken into consideration. I know that we are still dealing with housing providers that see an arrest and are saying no automatically, are not providing an appeal process. So we're still working with that actively. Let me see here. I think. So another protected class, sex. And there's multiple things that are within the category of sex. So domestic violence, reviewing VAWA, and nuisance ordinances typically are, and then criminal free lease rules are the typical things that we see that are in complexes or housing providers have. We want to ensure that folks are allowed to be safe and are not automatically evicted or asked to leave if they have called the police more than 3 times. Again, that's something that we're still dealing with. There's also, I'll leave it there. So there's HUD guidance on domestic violence. The link is shared. Best practice would be to ensure that you don't have a zero tolerance or an eviction-based DV or stalking policy, and ensuring that if there is a protective order, that the housing provider is ensuring that it's in place and that they know about it and not evicting folks for that. So like mentioned earlier, sex, gender orientation, and gender identity are covered under sex. The landmark decision, there's several here that are shared as far as ways that gender and sexual orientation and gender identity have continued to be protected and will continue to be protected. Again, same decision. There has been the guidance that was issued as well. Again, to city ordinances, ensuring. So this is a slide showing the cities that have protected gender identity and sexual orientation, and those that have done other protections. So we do applaud the cities that have continued to do the work on this. Familial status is another protected class. Like I mentioned, it's families with children under the age of 18 and or those that are pregnant. It does, again, segregation is very real, especially with families with children and or being excluded from housing. A lot of the things, the main cases that we've seen lately are complexes saying they're 55 and older, 62 and older, and saying there cannot be any children here whatsoever. But then as we conduct our investigation, we find out they're actually not 55 and older, and they're not 62 and older, and they're not keeping up with their rules and regulations of what they have to be doing in order to prove that they continue to be 55 and older or 62 and older. We've had some groups trying to change midway. So that's been taking some time to investigate, but we are still seeing these types of issues. So one of the main things that we see with familial status is occupancy standards. Under the Keating memo, which is HUD guidance as well, it does indicate that it's 2 individuals per bedroom plus 1 over the entire unit. So if it's a 3-bedroom unit, they're saying essentially 7 individuals would be okay to live there. we should take into consideration whether, depending on the size of the unit, but then also what the fire department would have to say about certain rooms and safety issues. So this one isn't so cut and dry. But we are still seeing these types of issues that occur. I would say that 60% of the cases that Intermountain Fair Housing faces or that it deals with is disability issues, mainly reasonable modifications not being accepted and or reasonable accommodations not being provided. So then this brings us to disability. Like I said, we are dealing with a large caseload regarding disability, and the main thing we go into is service animals. But essentially, reasonable accommodations and reasonable modifications, there is guidance, and I've provided, the link is provided. It does provide examples and FAQs on how to handle reasonable accommodations and what would be an acceptable denial. Essentially, an accommodation is anything changing a policy or practice, and a modification would be changing the structure itself. Depending on whether it's privately funded or federally funded would determine where the cost would lie. If it's federally funded, obviously the housing provider would have to move forward with that cost. If it was privately funded, the person seeking the modification is essentially asking to make the modification, but then they would be responsible for the cost. We do have forms on our website that lay out what a reasonable accommodation or reasonable modification would look like. We, under the HUD guidance, there is no standard form or there is no specific form. You can simply request an accommodation. You don't even need to say reasonable accommodation, and it should be known to the housing provider that you are asking for an exemption to whatever the policy is. One of the main ones that comes up is rent is due on the 1st. Say I'm a person with a disability and I receive Social Security disability income. That means my check doesn't get deposited until the 5th of the month. So one of the accommodations that we would potentially help with is requesting that the housing provider accept and allow the payment on the 6th of the month as opposed to on the 1st. That's one of the main modifications, accommodations that we help individuals with. Under the Federal Fair Housing Act, disability in fair housing is a little different than an ADA disability. So there are things to consider. With the accommodation form, you would be required to submit what is called a proof of need. A proof of need essentially is someone in a position to know, signing off that you do need this particular accommodation because of your disability. If the person doesn't have a disability, an accommodation essentially wouldn't be granted. If the person doesn't have a person in a position to know about the disability, essentially the reasonable accommodation wouldn't be granted. These are all factors depending on the facts of the case that we help individuals work through. So the other thing to mention is that if the individual has an obvious disability, you wouldn't necessarily be asking for a proof of need unless it's not obvious that the person has a disability. Again, who verifies? The letter would essentially verify that there is a disability, there is a need for the reasonable accommodation modification, and they need it to enjoy the dwelling. One of the things to share is as housing providers and or folks that are helping other individuals is to ensure that folks aren't necessarily sharing their diagnosis. That's not necessary, and doctors and or medical professionals should not be disclosing that information either, even if it is in a reasonable accommodation form or proof of need. We are asked, the HUD DOJ guidance also ensures that you're not releasing medical information, so you don't need to sign off on a HIPAA release in order to get reasonable accommodation or a proof of need done. So if that shouldn't be happening, and if it is, you know, you can refuse to sign that. One of the main things is if you do receive an accommodation request and or a modification, ensuring that you respond in a quick manner and not necessarily drag out the process. And there shouldn't be a charge for an accommodation. If there is, that's something to talk about and enter into the interactive dialogue with the client and or the individual to see what it is and what it's for, but typically there shouldn't be a charge associated with that. So also, when can it be turned down? So essentially, if for accommodations and for modifications, for accommodations, if it is an administrative burden typically, and or if it is something unreasonable. With modifications, again, it would be determined on if the person doesn't have a disability and or if what the person is requesting not associated to the disability, and or if the requirements for implementing or not getting permits and or the necessary documents or licensing in place in order to get the modification done. Again, you don't want to just say no. We want to make sure that you enter into the interactive dialogue, that you have a conversation with the client and or with the person to ensure that you understand what is being asked for and seeing if that's going to work. Sometimes what is being asked is maybe a no, but asking the individual, would this work, or would this work, or would this work, offering different alternatives or options. Again, some of the usual requests are, one of the main ones would be asking for an accessible parking space. We see this all the time. Individuals that have a caregiver that's coming to their home, they do typically request for a parking spot to be assigned, even though they may not drive, requesting that. Again, moving the date of when rent is due, depending on if they do have the medical necessity or the disability to, and service animals is a big one as well. So assistance animals. There is guidance as well that HUD has provided, and it has a webinar, there's a fact sheet, and there's interactive tools for assistance animals. We also do provide more extensive training on service animals and what we call assistance animals. There's so many different terminology for it, but essentially, if the individual is stating they do have a disability under the Federal Fair Housing Act, they do have a right to the animal. I know that that has been problematic in the past, continues to be. There has been issues with what the difference is between a service animal and an assistance animal. This kind of provides a little bit of more clarification, although it's not an extensive list. With regards to the Federal Fair Housing Act and assistance animals, the individual can have more than one assistance animal as long as the animal is for a different need. I know that that typically doesn't sit well with individuals, but unfortunately that's the law, and that's what their the right is. I know that there's been breed restrictions and weight restrictions for an assistance animal if the person has a disability and this specific type of animal is meeting that need. Those specific requirements wouldn't necessarily have to be followed. I know that we've had folks that have denied assistance animals, saying, oh, well, you can't have more than one, or you'll have to pay a deposit or this one-time fee. None of that is okay or allowed. So if you are seeing that, you can correct that. You can also send individuals to Intermountain Fair Housing Council so we can deal with that. Again, service animal, assistance animal, comfort animal, there's lots of different words. Essentially, the best practice would be to not say no to an assistance animal, to not charge pet rent or a deposit for it. I know that there's also housing providers that have been contacting medical providers directly. We don't ever encourage this because diagnosis can be shared, and that would be a violation. Again, if folks are having issues with anything regarding assistance animals, you can contact us to get more into those facts. Assistance animals is a little bit tricky sometimes, and we want to make sure that no one gets in trouble for allowing it or requesting it. So assistance animal okays. So ensuring it's okay to charge someone if the property has been damaged by the animal. It is okay to ask that the person with a disability pick up the waste. It is okay to ask that the animal be well behaved. I know that sometimes we get phone calls from housing providers saying, well, there's nothing I can do, and they're, allowing the dog everywhere or XYZ. There are things that you are allowed to do. One of the main things that comes to mind is folks are getting proofs of needs online. That is not seen as best practice. We don't encourage that our clients get proofs of needs online. I know that that's become very popular, and an assistance animal does not have to be a certified animal. It does not have to be registered under the ADA. Unless that is an ADA animal and you already have all those things so that you can go out in public and do all those things, that you can do that. But under the Federal Fair Housing Act, that is not required. So again, cities, HOAs, insurance companies have said no to service animals or no to a certain type of animal. If there are folks or clients that are dealing with this type of situation and need assistance, please contact Intermountain Fair Housing Council. I know that there's a specific insurance company that says no to pit bulls automatically. There is an accommodation request that can be made to the insurance company, so it shouldn't just be an automatic no. So one of the main things that we run into with emotional support animals and or assistance animals is the housing provider indicating the animal cannot be in common areas. Essentially, anywhere that the individual would be allowed is where the animal can be, as long as they're with them and assisting in whatever area they need to be. Again, best practice, don't consult with the doctor or the counselor. Ensuring that you're engaging in the interactive dialogue, you're having conversations about this, you're documenting anything and everything regarding lease violations, whether they're not picking up waste or whether the animal's not behaving, ensuring that doctors and counselors specifically name what the animal is for, and again, no automatic no's. So in order to be a fair housing provider, we are asking that we create generational wealth opportunities. So asking folks to accept subsidized housing vouchers, to support supportive housing, to ensure that the market rate housing is in place, offering ownership opportunities and or educating different individuals about what homeownership would look like in the city of Caldwell. The other thing, well, ERAP doesn't apply anymore, but again, Section 8 vouchers, this is a big one, especially because it's not required that all housing providers accept them. Again, coming back to, or if you think back on the first slide about how our community is already extremely overburdened as far as the housing that's available. So if there's 100 homes and only 30% is accessible to people that are extremely low income, this margin of housing that's available for folks with Section 8 and or vouchers is even smaller. So it's making our folks be even more housing burdened over the whole even finding affordable housing, because that's non-existent, unfortunately. So we need your help to ensure that we can continue that and do that moving forward for our community. So attached on top is Intermountain Fair Housing Council and our address, our fax, our email address. If folks need additional training and or more extensive training, we do offer a 6-hour training. We offer a 3-hour training. We have a bunch of trainings coming up. We are offering one in Boise. It's a 4-hour training, I believe. We are offering one in Meridian. That one's a 6-hour training. So we do encourage that if you all can participate, we would greatly appreciate that and or share with the community. And do we have any questions?
Well, thank you very much for the presentation. I do have a question before we get started, I guess, with everyone else. And so it's clear to me that you can do a background check, but you're saying based on that background check, you can't have automatic disqualifiers. Is that correct, or can you have them? I'm a little confused on that.
So with the criminal background check, you shouldn't have an automatic if there's an arrest. No. You shouldn't have if they had a felony. No. It should be on a case-by-case basis, depending on how old the conviction is or how old the arrest record is. It should be on a case-by-case, really depending on what occurred. If it is something that's older than 7 years, it should be something that should totally not be looked at. It's very much a case-by-case, and depending on the folks that are applying and what you're seeing as far as the convictions and or the felonies, if there's a felony.
Right. Thank you. Counselor
Yeah.
Stoddard?
Just a question too. Do you have to be a citizen to apply for this at all, or non-citizen, or?
So the Federal Fair Housing Act protects everyone. So regardless of legal status, the Federal Fair Housing Act would protect everyone.
So a legal citizen could actually have priority over a citizen then, obviously, right?
Well, with Intermountain Fair Housing Council, we help everyone. So it doesn't matter whether you are here legally or illegally, or if you're kind of in the middle. We are helping everyone protect their Federal Fair Housing right.
Yeah. I think the biggest drawback of this is probably, you know, as important as taxes are these days and everything, that, you know, people take a dim view of federal monies being spent for non-citizen people, or, you know, that's really it's a problem, so.
Well, just to reiterate, we want to be inclusive of all folks in our community. I understand that there may be different political views, but I know that for Intermountain Fair Housing Council and for the Federal Fair Housing Act, we help everyone.
Thank you.
Any other questions? We're good? All right. Well, thank you so much
Thank you.
for the presentation, Linda. And I guess that will conclude our workshop for tonight. And we'll see you again the next time we need a great update. We
Thanks.
appreciate it. Thanks.